Welcome to the Consumer Finance Podcast. Today, I'll be filling in for your usual host, Chris Willis, the co-practice leader of Troutman Pepper's Consumer Financial Services Regulatory Group. My name is Kim Phan, and I'm also a partner in Troutman Pepper's CFS Regulatory Group, as well as our Cybersecurity, Information Governance, and Privacy Group. For today's podcast, we are joined by James Kim to discuss issues related to Fintech. But before we jump into our interview for today, I want to remind you about our great blog, consumerfinancialserviceslawmonitor.com, where you can see all kinds of news and developments about everything affecting consumer finance. And if you like our podcast, please leave us a review on your podcast platform of choice. We're available on all the major ones. Just hit that review button and tell us what you think. So James, you and I and a number of other CFS folks recently joined the firm. What have you learned so far about Troutman's Fintech capabilities? And specifically, what are you bringing to the table that some of our Troutman clients might be interested in?
Thanks, Kim. I'm very happy to join you today for today's podcast. My practice and what I do is the same. I'm happy to continue it here at Troutman with my current colleagues and partners. What's exciting, I think, is all of the kind of new capabilities and the stronger platform that Troutman brings to the Fintech practice. We have a really deep corporate bench to do everything that a client would need. I think full service is really something that's very exciting at the corporate front. IP, copyright, trademark is an important need area for a lot of our Fintech clients, protecting a lot of their trade secrets as well as intellectual property. And then I think your area, privacy, data security, you're joining, and I'd love to hear your thoughts about it, but is a very deep and strong and well-rounded team here. I'm excited to kind of contribute and be part of this great team that focuses on Fintech, consumer financial services, be able to better service our clients.
Yeah, personally, I love the fact that the Fintech capabilities that we now have at Troutman are really soup to nuts from the beginning to the end of a Fintech's life cycle, when they're just emerging as new Fintech companies throughout their funding series, throughout internal setup of policies and procedures and compliance programs, to regulatory engagement and litigation, that we really have it all as a one-stop shop for Fintech companies. But let me ask you, Fintech is really a shorthand for financial technology. And I know that encompasses quite a few different types of entities: payment processors, mobile marketplace lenders, money transmitters. Who in your mind, amongst the world of Fintechs, make the most sense to engage Troutman in our services?
You are correct that Fintech is extremely broad, right? Because it's the intersection of technology and financial services. And nowadays, everybody to varying degrees is going to use or wants to use technology to better offer and deliver its products to its customers. So I think the focus is really in our strength, which is consumer or retail banking and financial services, and the ecosystem around it, right? So the companies that are actually touching the consumers, but all of their business partners, service providers, the banks that support them. So it's that ecosystem that focuses on what I would say are consumer and retail products is really our core strength.
You mentioned that ecosystem, and one of the areas that's more in my world, the privacy and data security world, is the reality that in that ecosystem, there's lots of different parties involved in any one particular consumer transaction. And you may be aware that there is this emerging patchwork of state privacy laws. So far, we've got California, Virginia, Colorado, Utah, and most recently Connecticut, who the governor signed into law their privacy law just yesterday. So it is a challenging environment for, I think, Fintechs who are just trying to get their feet under them to comply with the basics of regulatory requirements. And then you add this on top of it and the sensitivity that has to be treated toward personal information. Do you tend to find that Fintech companies have internal capabilities that are well built out for their legal and compliance functions, or is it something that they're often looking to outside counsel to?
I think it varies, but with earlier stage companies, it's, I think, rare for them to have that capability in-house. And I think in certain instances, those are not issues that they're particularly sensitive to. Understandably, right? I mean, The founders are trying to get a business off the ground. They're trying to acquire customers and scale the business and meet a lot of the targets and milestones set by their venture capital backers. I think compliance is something that they're aware of, but it's probably not top of mind and certainly should not be a blocker or create undue friction for them to grow their business. It is important to incorporate some, I think, selective or prioritized compliance or regulatory concepts and issues from the beginning so that you build it the right way. I've had fintech clients get off the ground and be successful and grow for a couple of years. They reach an inflection point where they're trying to partner with a bank or raise capital with more sophisticated institutional investors that have greater sensitivity to compliance issues. When they go through that diligence process, either where the counterparty is a traditional financial institution or more sophisticated institutional investors, the question is harder, and there'll be often regulatory issues become more prominent. And so I've seen fintech clients kind of have to backfill on those issues. And to a certain extent, that might be just unavoidable, and that's just kind of the path to growth. But I think there are ways to minimize that or be strategic early on to incorporate, like I said, certain select compliance regulatory issues, not all, to make it not only more painless down the road, but to help from a business perspective, right? Get a better valuation, get better pricing on debt, whatever the business terms are that you're negotiating with your counterparty or your investors.
Yeah, it is a complex regulatory compliance environment that fintechs live in. And in addition to state laws and regulations, we of course have to consider the federal, including and especially the CFPB, the Consumer Financial Protection Bureau. And my understanding is that the CFPB is and has announced that they're going to be bringing to the forefront what they characterize as a dormant authority to supervise certain non-bank entities. Can you tell us more about that development and how it might impact fintech companies?
This is I think, very important recent announcement from the CFPB that appears by all indications to be focused specifically on fintechs. And let me explain why. So before I do that, let's take a step back here, right? The backdrop is the CFPB has a new director, Rohit Chopra. Mr. Chopra, before he was or is the current director of the CFPB, he was a commissioner at the Federal Trade Commission. And he has a pretty substantive public record at the FTC on focusing on technology companies, right? So everybody can look it up. He has a track record of making comments that are often critical of large technology companies. And I think he carries that with him here at the CFPB, right? So I think he feels that fintechs and technology companies have been largely unregulated or underregulated. And so he's trying to address those gaps. And this is one of the important moves. And what is this move, right? So let's start with the legal fundamentals. Under Title 10 of Dodd-Frank, which is the statute that created the CFPB and gives it its powers, in Section 1024, the statute lays out the grounds or the areas in which the CFPB can supervise non-banks, right? So there's a different section of the statute that talks about the CFPB supervision of banks or depository institutions. And that one's pretty straightforward, banks that are over 10 billion in assets. For non-banks, supervision by the CFPB falls into a few categories. One is you offer a product that automatically gives the CFPB supervisory authority over you. And what are those products where if you offer or originate them, you are automatically under the CFPB supervisory authority? Those are mortgages, private student loans, and small dollar or payday loans. Okay, so kind of category one is you offer one of these special, what Congress deemed to be kind of special products that required heightened immediate scrutiny. The second bucket is you're a larger market participant. So if you're offering a product other than those three, the CFPB must engage in public rulemaking to define larger market participant for a particular market. So the rule has to define both the market and what the threshold is for being a larger market participant. Auto finance is one, student loan servicing is another, right? And so there are final rules in place that define those markets and define whether you're a larger market participant or not. And if you are a larger market participant, the CFPB has authority to supervise, meaning conduct examinations. The third category is this dormant authority that Mr. Chopra is now very publicly, very directly warning companies, specifically fintechs, that he's going to exercise. And that is, I call it a catch-all. It's this kind of catch-all backstop for the Bureau. It's any other company that doesn't fall under one of the existing or other supervisory buckets that engages in or has engaged in, right, so past or present tense, conduct that poses risk to consumers. Now, if that sounds subjective and unclear to you, I think that's intentional, right? It's meant to give the CFPB wide discretion to choose whether or not to assert this catch-all supervisory authority. Now, there is a procedural process that they have to follow. It's not a rulemaking process. It's something much shorter, where they give notice to a company that they intend to assert this catch-all supervisory authority, and you get to respond to it before the Bureau makes its decision. So there is a little bit of procedural due process, I'd say very limited, and ultimately the decision lies with the director. But it's this catch-all authority, right? So anybody else that doesn't already fall under supervisory authority that, engages in conduct that poses risk. And it's clear that fintechs are the focus of this. One, fintechs are mentioned in the press release, but two, fintechs have grown so much in the past several years that the regulator's just behind. They don't have the time or the inclination to engage in public rulemaking, which takes years to regulate and supervise a lot of these fast-moving emerging companies. So I think the CFPB needs to kind of dust off this regulatory tool that it didn't use very much in the past. So I think that, I'll pause there, but that's the headline. And, I'll comment about some of the particulars about it in a little bit, but I just wanted to see if you had any thoughts or reactions to that supervisory kind of authority being exercised, I think, in the near future.
Well, it certainly sounds like a very amorphous, looming threat against our listeners, and sort of reinforces the reality that the CFPB can pretty much do whatever they want. And if they want to come for you, they'll find a way. So that sounds like essentially what Chopra is saying here with this announcement. But I wanted to turn next to a CFPB risk that has not been formally announced, but I think has been seen trending in CFPB enforcement actions, is the new risk and reality that the CFPB is increasingly pursuing individual liability in enforcement cases. Do you want to elaborate a little bit on that?
Yeah, so there's no announcement here, but it's a clear trend, right? So we track consent orders and other enforcement actions, over years since the inception of the Bureau, certainly since when I was at the Bureau and since I left, because it's part of my practice. And we saw years ago under the first appointed director, Richard Cordray, that the CFPB used its authority to take enforcement action against individuals, and I'll talk about the legal authority in a second. And the CFPB named individuals as well as the company in lawsuits and enforcement actions, in consent orders and enforcement actions. That practice kind of fell by the wayside when the Republicans had leadership of the Bureau. And now that Mr. Chopra is the director, it's picked up again. And again, no announcement, but the pattern is clear. I'd say the vast majority of consent orders that have come out or lawsuits that have come out under Mr. Chopra, and he's still within his first year or so, often name an individual as well as the company, and in some cases multiple individuals. So I think that's the pattern that everyone needs to be aware of. Let me explain the legal basis for the CFPB's return to naming individuals in lawsuits and consent orders so that everyone understands where the authority comes from. In Title 10 of Dodd-Frank, there's a definition of related person. And in the statute, the CFPB has the same authority over related persons as they do covered persons, right? So any company that offers a consumer financial product or service is a covered person. And then any related person to that covered person is equally subject to the CFPB's authorities, including its enforcement authorities. I think the key part of the definition, and I'm not going to read the whole thing, but I think the key part is related person includes any director, officer, or employee charged with managerial responsibility or a controlling shareholder. It's interesting, the statute does not require that person to engage in any particular conduct. I think just by your role, you are a related person and you can be named in a lawsuit or consent order. So that's the legal basis. I think the important point for the audience is why. What is the purpose of the CFPB in naming individuals in lawsuits and consent orders? And I think the answer is, if we go back to critics, consumer advocates, and certain lawmakers after the financial crisis in 2008, the criticism, or I think the cry at that point was, hey, people cause the problem, not companies. It's people making decisions at the companies. We need to hold individuals accountable. And so I think Mr. Chopra believes that. He is ideologically and personally aligned and close with Elizabeth Warren. And that's been a talking point of Senator Warren's for a long time. And so I think Mr. Chopra believes that. And I think he believes that to have a true deterrent effect, he needs to name individuals. Otherwise, companies will kind of make these cold, calculated decisions to assume certain risk and potentially harm consumers because it's just cost of doing business.
Well, James, thanks so much for being on the podcast today and for sharing your insights on the always evolving regulatory landscape for the fintech industry. We hope you'll return soon to discuss in depth some of the regulatory issues we only hinted at during this very first of our fintech podcasts. And with that, I'd like to thank our audience for tuning in today. Be sure to subscribe to the podcast so you'll get our episodes every Thursday when they come out. And don't forget, we have lots and lots of other content in our blog, consumerfinancialserviceslawmonitor.com. Or you can sign up to our email list at troutman.com so that you can get copies of our webinar invitations, our client alerts, and other information about notable events happening in the consumer financial services world. And with that, I thank you and goodbye.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.